Once again, everyone with this huge amount of energy, welcome to the workshop. 3-day workshop. It's a 3-day workshop. Okay. So, everybody, please welcome. Okay. I want to definitely tell you, everybody knows about Lawctopus and Lawctopus Law School, I'm sure, because when I was also in law school, I think that one website that it was my go to website was Lawctopus. So, it's a 14-year-old, entity, and Lawctopus has really impacted many careers, including mine. Lawctopus Law School is a recent venture which creates effective courses and all kinds of practical courses and training programs for learners and law students to fill the void that is kind of created in law schools. Okay, we have taught more than 20,000 learners now with a 92.6 rating. Okay, and we take feedback from learners very seriously, so we work on those feedbacks and try to cover all the voids to be able to bring the most out of it, to be able to bring what you need. And this workshop is also one of them. Okay, you'll know why I'm saying that. Okay, just 1 second. You have two choices. Okay, one is either you can just attend this session on your phone, maybe, doing some other things, maybe just munching. I mean, you can, of course, you're allowed to munch and have coffee, no issues. But I'm just saying that you can just watch this session like you watch Netflix, maybe just generally, or just like how you listen to songs. Or the second choice is that you actually work on your you actually take this entire session very, very seriously, take notes, try to see what Shashank has to offer to you, because he is not only the academician who is going to tell you everything about theory. He's also a practicing advocate who has his own firm as well. He is going to give you some experiences and some practicalities which in the passing, maybe from here and there, which might actually turn out to be something really important for you. So please take notes, take it seriously. Choice is yours how you want to attend this session. Okay. All right. Of course, the speaker for today, as I said, is Mr. Shashank Sardesai. Okay. I hope you all must have already read about him. He's the co-founder of Evertrust Legal. Okay. He's a lawyer, plus, of course, company secretary. He's an independent litigator, also doing, corporate work. He's great at contracts. He's our faculty for contract drafting and negotiation, has impacted many learners now. I think more than, I don't know, Shashank, how many learners have you taught? I think more than 1,000 now. And everybody appreciates him, very humble person. He's worked with many firms, as you can see, like Khaitan Legal Associates, Vadia Gandhi, HSA Advocates. And after learning so much, he's decided to start his own firm. Now, currently, he's also practicing at the Bombay High Court. He's taken variety of cases, works on diverse, complex issues, civil, criminal, constitutional, NCLT, company matters, arbitration matters. So many matters are there. So he actually has seen everything, being dissected in a court, and that's what he has to share with us today. Today, you're actually going to hear something from him which you can only probably hear from a very close mentor of yours when you're having a conversation. Okay. So yes, this is about today's session. Few small 2 or 3 logistics that all of you should definitely remember. Throughout the session, if you have any questions, please post it on the Q&A box. Okay. Do not miss out on the Q&A box. I don't want to miss out on your questions. Okay. If you're going to post it on the chat box, it might get missed out, and I don't want that. So please put it on Q&A box. What we'll do is Shashank will cover a substantial part of the content, and then we will cover a few questions. Then again, we'll proceed with the content and cover a few questions. We'll try to cover as many questions as you have. And all of you, after the content is over and the questions are over, you have a bonus registration opportunity for 30 minutes only. Okay. And I really recommend and insist with my complete heart and soul that you should definitely stay and listen and explore to what we have in store for you. Okay. So everybody clear with it? Voice is low. Is my voice low, Shashank?
No, it's perfect.
Fine. Others, is my voice okay for all of you? If you could just give me It's fine. Okay. So Venkat, Bhanu, I think you'll have to just quickly check your microphone or maybe try rejoining. Okay. Okay. Now, for all those who attend all the 3 days of the workshop, we have a small, what do you say, like an invaluable reading material that we're going to be giving to you guys, which is again very helpful in practical litigation skills. So that will happen at the end of the 3 days. So that will only happen with the people who attend all the 3 days with commitment. Okay. Regarding certificates, I am just quickly telling you, we do not encourage certificates, but I understand that you guys need it for your college and for other things. So at the end of these 3 days webinar, I am going to 3 days workshop. I am going to share the logistics for certificate. How will you be able to download it? What is the code for it? What is the link for it? Everything I will share it with you. Okay. This is the certificate is upon completion of all the 3 days. Okay. So completion of 3 days, you get two things. First, you get a certificate, and second, you get a free reading material. And third, of course, you get a huge package of skill that is invaluable for all of you. Okay. So everybody clear with this agenda? Can we begin the session? Okay, awesome. I hope everybody has a notebook, a pen, and a water bottle so that you don't have to get up and go get the water bottle. Okay. Pens and notebooks are a must. If you don't have, quickly get up, go grab it and come. Okay. So now, without any further ado, without any other introduction and agenda setup, everything is done. You are clear. I am clear. Now I am passing it out over to you, Shashank. Really looking forward to the next 1.5 hours of learning from you.
Thank you so much, Akansha. Thank you for the nice words and also creating such a vibrant energy. So, guys, I hope everybody is going to maintain the same energy throughout the session till 9 o'clock. Yes. Can I get some, like Akansha said, favorite emojis or thumbs up or something? Okay, amazing, amazing. Okay, guys, welcome to today's session. Today is the first day of the webinar. So today we are going to be discussing about courtroom procedures and skills, and trust me, I'll try to make it as practical as possible with a lot of fun examples and an interactive session. Like Akansha said, whenever you have a doubt, don't forget to put it in the Q&A, so that in the Q&A session we can address it there and then. Okay. At any point of time, if you feel that my audio is not audible, or let's say the video is not visible, or my pace is too fast, please let me know in the chat box so we can we can address it. Okay, everybody clear? Okay, so I'll just share my screen now. Okay, and you guys can let me know if the screen is visible. Amazing. Okay, okay. Now, so today's session is about courtroom procedures and skills, but before we dive into, courtroom procedures and skills, because courtroom procedures and skills is everything to do with litigation, right? So we must first understand the core or the basics of litigation. And that is why I'm going to present the first slide on, civil and criminal proceedings. First, let's understand the basics. Okay. And the reason I want to do this is because this is not a theory class. We want to make it as practical as possible. Okay. We'll dive into the basics first. And then, of course, we'll study the stages, fundamentals, a lot of fun examples, right? So let's begin. Okay. Now, the reason I want to cover this is so that this will make the rest of the, topics very easy. Okay. Now, I'm sure you guys know about this, but, just a quick refresh. Okay. So basically, if you see proceedings in India, or you can even say, all over the world, are divided into two parts. Okay. One is the civil side, one is the criminal proceedings. Okay. You might have heard oftentimes, people, lawyers asking each other, or you might have, if somebody's a lawyer in your family, you might have, heard them talking with each other that I practice only civil law, I practice only criminal law. I take up only civil matters, I take up only criminal matters. Okay. So what is civil proceedings and what is criminal proceedings? That's very crucial to understand first. Okay. So let's understand that. Now, when we talk about civil proceedings, the basic meaning, absolute basic meaning is that civil proceeding or a civil matter arises when there is a wrong done, against a private party. Okay. It is a civil wrong. Okay. Let's take a very simple example. Let's say that you and I enter into a contract. Okay? We enter into a contract and I breach certain part of the contract. By breach, I mean I break the contract. Now, what is the remedy do you have? Okay? There is no crime that I have committed. The remedy that you have is to approach the civil court. Correct? So, in such an event, what you will do is you will initiate civil proceedings against Mr. Shashank Sardesai. Okay, so this is basically civil proceedings where there is no crime involved. Okay, criminal proceedings, on the other hand, let's take a similar example. Let's say I come to know your address and I decide to commit a burglary or a theft in your house. Now there is no breach of contract. I have straight away decided to commit some kind of burglary, theft, some kind of crime. Now what is the remedy you have? You have the, of course, the natural and the obvious remedy to approach the police, right? What you will do is you will go and file a FIR, first information report, or a police complaint against Mr. Shashank Sardesai. Okay, and that is what will constitute a criminal proceeding. So the funny images which you can see on the screen right now, one is the breach of contract in the first example that I spoke of, and second is the criminal proceeding where you can see Mr. Shashank Sardesai looting some gold out of your house. Okay, so this is all about civil proceedings and criminal proceedings. We'll be going, don't worry, we'll be going into the depth of where to file, how to go about it, and everything. Okay, so tell me, guys, everybody is clear till here? Yes, some emojis in the chat box. Okay, amazing. Everybody's good with the pace, volume, video, screen sharing, all of it is good. Okay, perfect, perfect. So let's keep up the same energy. Okay, now let's go to the second slide. Okay, now before we move on to stages of proceedings and everything, I just wanted to discuss a few fundamentals of proceedings. These are not limited to civil or criminal. I'll discuss it if it is specific to civil or criminal, but these are a few fundamentals which I thought are very practical and which come in very handy when we discuss litigation. The first thing that you see on the screen, the first fundamental that you see on the screen is jurisdiction. Anybody would like to take a guess what we mean by jurisdiction? Anyone in the chat box? We've heard this term, right, a lot, especially in moot courts, right, where where we hear which court has jurisdiction and everything, right? So court's power, absolutely, you guys are all absolutely correct, right? Jurisdiction is basically power of the court to try a case. Okay, so I would first want to discuss the meaning of these two words that you see on the screen right now, and then I'll explain with an example so it becomes easy. Okay, jurisdiction is basically the power of any court to try a case. Okay, by try I mean, let's say you file a case in a particular court. The first thing that the court will assess is whether that court even has the power to entertain you and the case that you have filed. That is the jurisdiction. Okay, now these two things, these two words that you see on the screen, that is territorial and pecuniary. Okay, very simple. Territorial means the area based on which, or the land, or the territory based on which that court has jurisdiction. Pecuniary, on the other hand, means the monetary value or the value of the suit or the case that you are filing, which gives that court that power. Let's understand with a very simple example. Okay, let's say that Mr. A and Mr. B enter into a contract. Okay, now Mr. A and B are entering into the contract in Mumbai, Maharashtra. A and B both also reside in Mumbai, Maharashtra. The contract is executed. By execution, I mean it is being signed in Mumbai. Okay, now as per the rules of CPC, Civil Procedure Code, or let's just say as per the law, the court which the parties can approach in this case will be the lowest court in Bombay. Okay, let's say that A and B, after entering into the contract, A breaches the contract, A breaks the contract. Now let's understand this. The remedy, the correct remedy, or the correct court which Mr. B has to go is the lowest court in Bombay. Okay, Mumbai. Why? Because the contract is executed in Mumbai. Both of them are staying in Mumbai. So the law has a rule that Mr. B must file his case against Mr. A in Mumbai. Okay, everybody clear till here? Anybody who did not follow the example or anything? Okay,
Everyone,
now,
I'm so sorry, Shank. Is everyone able to see the PPT? Okay, it is visible, right? Okay, awesome.
okay, thank you. So now in this example where there is A and B are fighting and B has filed a case in Bombay, lowest court in Bombay. So that is the city civil court, what we call over here. In other states or cities, they are also called the district court. They are also called civil judge junior division and everything. Okay. Now, however, there is a small twist. Now I'm adding a twist to the story. Now, in this case which B is filing, B is claiming that the court should direct A to pay B 20 crores. a sum of 20 crores. Let's say his his valuation, his claim, he feels that A should pay him 20 crores. Now, in such situations, what the law says is that if the value, okay, if the value of the case is exceeding a certain amount, then you need not approach, or you cannot approach the lowest court, okay, in that city. Then you must directly approach the high, okay. So see how the law changed the rule when the value of the case changed, okay. So far, in the first example, till the time the value was below 20 crores, B was filing the case, was required to file the case in the lowest court in Bombay, lowest civil court in Bombay. But the moment value of B's claim increased 20 crores, what the law says that you please directly file this case in the high court, because only high court can deal with such a big value, such a high value case. That is what we call the pecuniary jurisdiction. Okay, pecuniary is just a fancy word, but it all means monetary or the financial jurisdiction of the court. Okay, based on the valuation. So these are two aspects that we need to understand. One is the territorial, based on where the dispute is arising, where the parties are staying, and two is pecuniary. That, in very simple words, if your value of the suit or the case that you're filing is exceeding, say, a certain amount of rupees, okay, then please directly approach a higher court, because the lower court does not have the power to do. Now, where do we understand all this is, different states have different rules. Maharashtra has made a rule, for example, that below 10 crores, you approach the lowest court. About 10 crores, you approach the high. Other states have different rules, okay. So this is the way territorial and pecuniary jurisdiction is decided. And before we go ahead, I want to understand if everybody followed this part, territorial and pecuniary jurisdiction, from very start to end. Yes, guys, clear? Any doubts so far? Amazing, right? Okay, perfect. Okay, now we'll move on to more and more interesting examples and interesting stories. Correct court slash forum. Now, this is something as a fundamental which I wanted to include, because this is a mistake that a lot of practicing lawyers also do. What I mean is that when a case comes to any lawyer, or when let's say a case comes to you, right now you're a law student, let's say tomorrow you're practicing, it is very important that as a lawyer you decide the correct course of action. Okay, trust me, in any case you will have 10,000 options, okay, 10,000 remedies available. Okay, let's take a very simple example. Okay, let's say that Mr. A books a flight, okay, to go to Dubai. Now he books this flight with a very famous airline, okay, and at the last moment this airline cancels the flight and even refuses to refund the money. Okay, now you guys tell me, from whatever little bit of understanding, you guys tell me, where do you guys think Mr. A should file a case against this airline? Anyone, any guess? Consumer forum. I'm really amazed to see so many of correct answers, right? Consumer forum. But now guys, see over here, understand that Mr. A had the option of consumer forum. His lawyer also could have advised him to file an FIR against the directors of the airline. His lawyers could have also advised him to file a suit in the the district court asking for damages and compensation. Okay, but this is the understanding and knowledge that lawyers must have, which I'm so happy to see that all of you, most of you already have, and it's amazing to approach the consumer forum, right? Why? Because this is a case where Mr. A is the consumer, okay, and there is some kind of deficiency in service from the airline, correct? So therefore, in such an event, deciding the correct course of action or the correct court or forum is very crucial. Clear, guys? Yes, amazing. All of you guys have given the correct answer. I'm really happy. Airport place is also actually one of the correct answers. I'll tell you, in one of my practical experiences, I have come across a case where the consumer forum actually questioned the lawyers whether you had approached the airport authorities or not. So that is also a very correct answer. Okay, so this is what we mean by the second fundamental. Now moving on to third fundamental, that is res judicata. Right, res judicata and parallel proceedings. Res judicata is something which I'm sure you guys are hearing a lot in law school. Even we heard it a lot in law school. Okay, and it's a very interesting concept. Okay, res judicata. Before moving to the meaning, let me just give a very simple example. Okay, let's say that Mr. Mukesh Ambani, okay, files a case against Mr. Anil Ambani. Okay, saying that Mr. Anil Ambani has defamed Mr. Mukesh Ambani. Defame meaning has posted some kind of derogatory, some kind of remarks on public platform, because of which now Mr. Mukesh Ambani's reputation has gone down. Okay. Now what Mr. Mukesh Ambani does is Mr. Mukesh Ambani files a case in the court, okay, saying that defamation suit is filed, a defamation case is filed against Mr. Anil Ambani. Now the court decides it for a period of 5 years, and after 5 years, the court decides against Mukesh Ambani. So what the court basically says that there is no defamation. Okay. Now Mr. Mukesh Ambani is not very happy with this decision. Now you guys tell me, after 2 months of this decision, can he really once again file a new case on this entire chain of events, saying that back in this year Mr. Anil Ambani defamed me and everything? Can that really be done? Appeal is there. Yes, appeal is there. No, I'm not talking about appeal, but can he file? No, he's not challenging the decision. He wants to file a similar case before the same court. Can he do that? No, right? That is what is, in very simple terms, res judicata. Okay, if a particular issue has been settled between the parties cannot reignite that issue. That is all. Okay. As far as so I hope res judicata is clear with everybody, right? Because the case has been heard and it has been decided, and the court will say that this is an issue which has been decided between the parties, and therefore, Mukesh Ambani will not be allowed to file the case on the same cause of action. Correct? Okay. So that maxim is very clear. Okay. Now, when I say parallel proceedings, okay, let's take another example to understand parallel proceedings. Okay. Parallel proceedings is basically, let's say that Mr. Salman Khan and Mr. Shah Rukh Khan enter into a contract. Okay. And Mr. Salman Khan breaks the contract. Now Mr. Shah Rukh Khan files a case against Mr. Salman Khan in the civil court for breach of contract. Okay. Now, can you guys tell me, this is a civil dispute? Can Mr. Shah Rukh Khan file a police complaint in this case that Salman Khan has committed a fraud? No, right? Why? Because this is clearly a civil dispute. Police anyway is not going to entertain. Okay. So therefore, it is advisable to not pursue parallel proceedings unless allowed by law. Okay. So let's be very clear. Res judicata, in very simple words, is where a dispute has been decided between us. We cannot reignite that decision. We cannot again reignite that dispute by approaching that court or any other court on the same cause of action. Okay, that is res judicata. Parallel proceedings I have discussed because it is very crucial to understand, when you're taking up a case, if there are parallel proceedings going on. Okay, let's say if it is a civil dispute and if your client is attempting to file an FIR, that cannot be done. Correct. Now, fourth element is the Limitation Act. Correct. Limitation Act. How many of you guys have heard of Limitation Act, and what do we mean by limitation? Anybody? Any guesses? Yes, guys. Limitation. Time to file a case. Absolutely correct, Ajit. Within that period, Noreen is also correct. We have to file a case. Time period. Absolutely correct, Sandeep. So I'm happy. So we all know what limitation is. Correct. So limitation is basically, in very simple words, the time period that you have to file a. Okay, this basically comes from a very interesting maxim. One cannot sleep over his or her rights, right? So let's say that if I am the landlord and you are the tenant, okay, I give you my apartment on rent, okay, and let's say it's an agreement for 5 years. Okay, and I give you my apartment on rent. You're supposed to pay me a rent of 50,000 per month. Now, let's say you start defaulting, you start failing to pay on the rent, but I don't do anything for 3 years. Okay, I don't do anything for 3 years. I sleep on my rights. In the fourth or fifth year, I think, okay, fine, you've not paid the rent, so might as well go to the. Now, in such a case, the court is clearly not going to entertain my case for the very simple reason that I really slept over my rights. I did not take any action for 3 years. Okay, 3 years is the common or the general period which is given in the Limitation Act for initiation of any action. If I did not take any action for those 3 years, now I cannot come in the fifth or sixth year and say that, back in 1999, Mr. XYZ did not pay my rent. I cannot do that. That is all that is there in limitation. Okay. Did you guys follow? Limitation? Yes, Noreen. Like for suppose 30 days, which can be extended up to 60 days or one after which it can. So reasonable, of course, it can be condoned, like Noreen has mentioned. However, there has to be probable cause. Okay. But we are talking about ideal scenarios. We would, of course, advise to, all the clients and everybody, all the lawyers also too, if they're initiating any action, make sure that it is within limit. 3 years, Somnath, is maximum. Okay. For most of the actions. For some specific actions, it's lesser also. For example, if you take Consumer Protection Act, it provides a limitation of 2 years only. Okay, so it depends from a case to case basis, but 3 years is generally the maximum. Okay, everybody clear with limitation, guys? Yes, great, great. Okay, now next fundamental is interim reliefs, and that is the most favorite topic for all the practicing lawyers. And if you guys are also very passionate about litigation, please hear me out carefully. Interim reliefs is the most crucial topic. Okay, let's understand. Okay, like all the fundamentals and all the topics, I'm giving a story or an example. So let's understand with an interesting story. Okay, let's say that I own a plot of land. Okay, I'm owning this plot of land. I have my 100-year-old house on that. Okay, built on that plot of land. It's a generational house. Okay, my forefathers, grandfathers, everybody has been staying there. Now the house is in a very bad condition. So therefore, one builder approaches me and he says that let me demolish your house. We'll enter into a contract. Okay, development agreement it's called. Very simple it is. We'll enter into a contract, and what I will do is I will demolish your house, okay, within 3 days of this contract, and I will build a very beautiful building over there. I will sell some portions to others, and I will also give you one very nice flat free of cost. So that is the deal between me and the builder. We enter into the contract. Okay, so deal is very simple. He's going to demolish, he's going to break my house. Okay, after that, he's going to construct a building over there, and he's going to give me a house to stay, and the remaining flats he will sell. So it's a win-win situation for everybody. Now what happens is after we enter into the contract, I come to know that this builder is a very established criminal. He's a gangster, and he has a lot of police complaints and a lot of criminal cases to his name. So I definitely, after signing of the contract, I do not want to now go ahead with the deal. I do not want him to construct anything. I do not want him to break my house, demolish my house. I just don't want to go ahead with the contract. So what I do, let's say I send him a termination notice saying that let's cancel the contract. I don't want to go ahead with this contract. He doesn't reply. So now I file a case in the court saying that I want to terminate this contract and I want this much as compensation and everything. Now what happens is after I file the case, Mr. Builder comes to my house with a JCB, right? He comes with a crane, JCB, tractor, everything, and he starts breaking my house. So what happens over here? He says that, see, boss, Mr. Shashank Sardesai, I am breaking your house because under the contract we have agreed that I will be allowed to break your house within 3 days. 3 days are done, so I'm breaking your house. Now, what do I do? Right? Now, what I do is I have to go to the court and I have to file an application for interim relief. Interim meaning in the middle. So, leaving aside the suit and every case that I have filed against him, I go to the same court in which the case is filed, and I tell him and I tell the court that Mr. Builder is coming with a crane to my house and he's wanting to demolish the house, and he's come with a crane, tractor, and everything. Okay, and please pass an order to stop him. Okay, we will discuss the merits of the case later, but first today accept this interim application, first pass an order so that he does not demolish my. This is basically an interim relief. The court hears me and the court then passes an order saying that please do not demolish Mr. Shashank Sardesai's house till the time this main case is decided. Okay, so this becomes an interim relief. Okay, so now you guys tell me, did you guys follow interim reliefs? Temporary relief, temporary injunction, absolutely correct. Okay, I hope you guys are also taking note of these examples. Trust me, these examples come very handy, 6 months down the line or years down the line when we tend to sort of get confused with a particular concept or something, right? So that is interim relief. Okay, and what you see next to it is ad interim. It's very simple. Interim relief is, let's say if in this example the court said that Mr. Builder cannot touch my house till the suit is decided, it's an interim. If the court instead passed an order, instead of this, if the court passed an order saying that Mr. Builder cannot touch Mr. Shashank Sardesai's house till 31st of December, the next date on which this matter is kept, or next date of this case, then that's an ad interim relief. It is only extending till the next day. Okay, that is all that is there in interim and ad interim. Fairly simple. But if you guys get an clear understanding and clarity of these concepts, trust me, litigation will be very simple. Clear, guys? Everybody clear? Can I get some responses? I hope the energy is still there, right?
Okay, Shashank, maybe we can take like one or two questions.
Sure,
And
sure, sure.
guys, I would really want your 100% participation for you to be able to take these terminologies, understand these terminologies, okay? So, Shashank Kubar is asking, what is the difference between interim relief and injunction?
So injunction is basically a type of an interim relief. There are different types of interim reliefs that the court can grant. Okay. For example, in this example, the court could have appointed a court commissioner. Basically, just a person who would, stand at the property, who would seal the property. That's an interim relief, right? Injunction is basically also an interim relief when the court asks the party to do something or the party to refrain from doing something. So if over here the court would have asked the builder to not touch my property at all, that would have been a temporary injunction.
Okay, great. And Kevin and others, I would request you to please post your question on the Q&A box so that I will be able to cover them. Okay, Somnath is asking Shashank, who decides the value of the suit? Does the plaintiff decide the value of the suit?
Yes, the plaintiff decides the value of the suit. It is dependent on the, let's say you and I, Somnath, enter into a contract. You sell me goods worth rupees 2 lakhs, okay, and I don't give you the money. So 2 lakhs is your base amount. Over and above that, you may also want to seek some damages of 5 lakh for litigation expenses, lawyer expenses. So you add 5 lakhs to 2 lakhs. It becomes then 7 lakhs. Then you want to add 3 lakhs for mental harassment, then it becomes 10 lakhs. So you are the one, that is the plaintiff is the one who will decide the value.
Okay, great. Ajit, your question for criminal offense, I'm not very clear with your question. Could you please, rewrite your question? If you're here, please rewrite your question on the Q&A box and I will take it fresh, okay? All right. Saket is asking, can you please repeat the ad interim part once more?
Sure, sure. So, see, Saket, very simple. I'll just take the same example. I know I'm repeating, but it will become very easy with this example only. Okay. In the same example that I took, let's say I went to the court, I complained about the builder, I filed my application for interim relief. In that, I asked the court that, please tell him that till the time the main case is decided to not touch my house. Now, the court says that I don't want to do that. The judge says, but maybe till the next date we'll keep this case on the 31st of December. At least till the next date, I will tell him not to touch your house. So I say, okay, I am perfectly fine with that. This becomes an ad interim. Why? Because this is not granted for the duration of the entire case. This is only granted for a certain period, for a 1 month period, 2 month period, till the next time the case comes to the court. Okay, till the next date of the case. Got it, Saket?
Okay. Thank you so much, Shashank, for the explanation. So, Ajit, I'm talking about the time to file that case. Okay, so time to file a criminal offense. I mean, in case of criminal offense, also, is there a limitation period to file the case? Shashank, maybe I think that.
Generally, there is no limitation for a criminal case. Okay, of course, there are what has happened is that High Courts and Supreme Courts have established principles that you cannot 10 years later come and file an FIR. It's not that the police will not entertain, police will entertain if probable cause is shown, and even the courts will have to entertain. But of course, even in criminal cases, limitation is not to be taken lightly. Having said that, answer to the query is that in civil cases, you have a limitation. In criminal cases, per se, there is no limitation.
Okay, awesome. Okay, Shashank, could you quickly just briefly repeat the parallel proceeding aspect as well?
Sure, sure, sure. See, parallel proceedings are where parties are doing forum shopping. We call it forum or court shopping, right? So, where basically there are different strategies or different options available, it is important to choose the correct option. Okay. So, when I say parallel proceedings in the example that I had taken between Shah Rukh Khan and Salman Khan, there there was a clear breach of contract. Okay, breach of contract is a clear civil proceeding, right? A civil proceeding can arise out of it. Now here a criminal proceeding will not be entered. So the reason why we are discussing this fundamental is for us to know that parallel proceedings generally needs to be avoided unless allowed by law. There are certain situations, for example, proceedings under the Consumer Act and proceedings under the RERA Act, they may be allowed to be pursued simultaneously, but in general, unless allowed by law, parallel proceedings should be avoided. In this example, for example, Salman Khan and Shah Rukh Khan, if it's a clear civil dispute, only the civil court should be approached and no parallel proceedings before the police or something like that should be, adopted.
Okay, great. So, I mean, it's also logical learners. I mean, if you have initiated proceedings in one, channel, then you are not supposed to initiate another proceeding, with a different angle. Okay, so to avoid multiplicity of proceedings, and also civil and criminal cases in parallel cannot go together. So that is exactly why this is not allowed. Okay, awesome. All right. A lot of them are asking questions on interim relief. So,
Okay,
Shashank, I think if you could just give like a basic
sure.
understanding of ad interim, what is the difference between ad interim and injunction, and how many types of interim reliefs are there? So that could, I think, answer many of your questions.
Okay.
Your,
See, interim relief is basically, let me break it down. Okay. Interim relief is basically a very practical term, very litigation term, which is used in courts. Okay. It arises from injunction only. Okay. Your injunction arises from Specific Relief Act, correct? Where there is a temporary injunction and a permanent injunction. Okay. So these interim reliefs can be in the form of injunctions. Okay. There can be more also. Okay. For example, like I said, the court may, appoint a court commissioner over a disputed property, basically a person who will seal the property, like I said, or the court may pass an order of injunction. Now, injunction is an interim relief only, so let's not get confused with that. Okay, interim and ad interim are just courtroom terms. Okay, they arise from the concepts of injunctions and specific relief acts only. Thus, I hope.
how many types of interim reliefs are there, Shashank?
So generally you will have them divided into two parts again, okay, temporary and permanent, okay, where temporary either an injunction may be granted or even permanent also permanent injunction may be granted. So temporary and permanent is what we divide them into, and even appointment of court commissioner or anything can fall into temporary or permanent.
Okay, great. Awesome. Okay, guys, I will be taking your questions again in a while. So I think, Shashank, we can definitely move forward.
Okay, thank you so much. So now, last fundamental that I wanted to discuss was court fees. Okay, I hope everybody, I'm sure everybody has heard of this or knows this. Court fees is nothing but the amount of fees that the person who is filing the suit in the court has to pay. Okay, so let's say if I'm filing a case against you, and I am saying that you have broken the contract, breached the contract, and if I'm claiming 10 lakhs, then I will have to look at the state court fees act. If I'm filing the case in Bombay, I have to look at the Maharashtra court fees act. That will give me a clear idea that if I'm filing a case for 10 lakhs, what is the percentage of fees, percentage of rupees that I need to pay as court fees. Why do we pay that? It's obviously because when somebody files a case, they are going to utilize the services of the judge, or they are going to utilize the services of the courtrooms, the staff, the institution, the building, everything, right? There's a lot of paperwork also which goes from the court side. So there are fees taken from everybody who files a case. Okay, these are called the court fees. Is everybody clear with the concept of court fees and why we pay them? Now, moving on. Can I move on, guys? How do we get to know the court fees? We get to know the court fees from the state's court fee act. If you're filing a case in Delhi, you have the Delhi Court Fees Act where you can get a list of the table of the fees that you have to pay based on the value of this. Now, guys, key stages in civil proceedings. I just wanted to cover. I thought it's a very interesting topic to cover. Okay, and there's a lot of confusion amongst a lot of practicing lawyers also as to what comes before, what comes next. Even I had the confusion when I was in law school, and even when I started practicing, honestly. So let's begin. Okay, now the first step is filing of a plaint. Okay, filing of a plaint is nothing but filing of a case. Okay, we call it plaint because it's the terminology. Okay, whatever suit or plaint that gets filed in the court is your case. Okay, so that is the filing of plaint. Okay, it's basically, in very simple words, it's a document containing the facts, the grounds, the reason why I'm approaching the court. Okay, my whatever I am saying, that you breach the contract that we had, then I file a case against you, then I will file a plaint in the court. I will give the details of our transaction. I will say that how you breach the contract and everything. Second stage is the issuance of summons. Now I have filed the case, okay, against you. Now, how will you come to know that I have filed the case against you, right? You will not, out of the blue, have an announcement done to you that Mr. Shashank Sardesai has filed a case against you, right? So what happens is the moment I file a case, okay, the court will call me, the court will ask me, why have you filed this case and everything? Whom have you filed it against? So then I say that, I have filed it against Mr. B. Mr. B, broke the contract and everything. So the court sees the address of Mr. B, details of Mr. B, and then the court issues summons. Okay, summons is basically a document issued by the court in which the court asks Mr. B to remain present or file the reply on the next day. Okay, fairly simple. Everyone fairly simple with this part. Okay, third is filing of interim applications. Okay, remember the builder example that we just spoke about. Okay, and don't get it confused with injunctions. Okay, basically injunctions, you can, if I have to break it down even more, injunctions are the theoretical part. Okay, interim applications is the courtroom language that is used. Let's say you want to seek an injunction against me, you will file an interim. Okay, that's how it operates practically. Okay, now fourth stage that you guys see on the screen is filing of written statement. Now this is very interesting, right? Now in the example that we had taken, Mukesh Ambani had filed a case against Anil Ambani. Let's say that case was false. Now how does Anil Ambani tell the court that the case is false? Can he just come to the court randomly one day and say that, that case that is filed against me by Mr. Mukesh Ambani, that is false? No, that can't happen, right? So what Mr. Anil Ambani can do is he has the right to file a written statement, basically a document containing his defense. In that, he will deny everything and he will say that, this case is false, and Mr. Mukesh Ambani is my brother, but I am not defamed him, nothing has happened, this, that, everything. This is his chance to do that. Filing of a written statement by the defendant or the party against whom the case has been filed. Okay, so that's what we mean by written statement. Then you have something called as production and inspection of documents. This is very simple. It's a very practical aspect. The party who has filed the case can produce further documents, okay, original or copies or whatever, and the defendant against whom it has been filed can take inspection of documents. This inspection basically happens in the court only. The plaintiff or the party who has filed the case will, submit further documents or something, in support of their claim. The defendant can then go and carry out an inspection of these documents. Okay, then you have the framing of issues. Okay, now this is something very interesting. Okay, let's take a very simple example. Okay, let's say that Mr. A sold Mr. B certain goods. Okay, and Mr. B did not pay for these goods. So these goods were like worth rupees 5 lakh rupees, and Mr. B just did not pay for these goods. What does Mr. A do? Mr. A files a case in the civil. Okay. Now, in this story that I have taken, in this example that I have taken, the issues that the court will frame, issues are framed by the court. The issues that the court will frame will be whether Mr. A provided goods to Mr. B, whether they were supplied or not. One. Two, whether Mr. B failed to pay for these goods. Okay. Why are these issues being framed, guys? Because now the parties have submitted their documents. Now the court wants to come to a conclusion as to what are the questions to be decided, right? If there is no question to be decided, there would not be any case. So now the court wants to understand what is the question that I decide in this case. The question that the court needs to decide is whether A provided goods to Mr. B and whether Mr. B failed to pay for these. So that this is the stage we call framing of issues. Clear, guys? Everyone clear? Okay. Great, great. Now the next stage after that is chief examination, okay, and cross examination. I'll explain this with a very simple example. Okay, let's say my client, okay, is a person who had provided goods to somebody, and that person just did not pay. Let's say in the same example, okay, Mr. A and Mr. B. So Mr. B, what he did was he gave some checks to Mr. A. Now these checks bounced. Okay, now Mr. A files a case, okay, against Mr. B, okay, that the checks have bounced. What happens in the examination in chief stage is that I submit a document which is signed by Mr. A, in which Mr. A again reiterates everything that is mentioned in his case and says that how the checks have bounced, these are the original, and I have seen him signing the checks and everything. This is the examination in chief stage. In very simple words, examination in chief stage happens with procedurally the party who has filed the case again files another affidavit giving details of what all has happened and what are the original and the copies of documents that are relied upon. That is the examination in chief state. Okay. Cross examination is basically, now let's say you are Mr. B's lawyer. Okay. You do not believe that Mr. B failed to pay for the goods or anything. You feel that, Mr. A has filed a wrong case and Mr. Shashank Sardesai is also assisted in filing a wrong case, okay, fictionally. So what you do is, in the cross-examination stage, you as a lawyer call Mr. A in the witness box and start questioning Mr. A. That when did this transaction happen? Were you present when the checks were signed? This, that, everything. So you are now cross-examining the witness who has filed the case. Okay, this is what is cross-examination. Okay. Then you have final arguments and judgment, which I believe doesn't need much explanation. First, I want to understand if everybody has followed the examination stage. Yes, guys, clear? Very simple, okay, nothing complex, but it's very crucial that we discuss these stages, right? This is how it works practically. In the final arguments, of course, both the parties lawyers come together and they present their arguments, right, one after another. Judgment is the final order which the court passes in the case, deciding the case. Let me tell you one thing, that these stages differ from city to city, state to state, right? Cross examination, yes, I'll explain once again. So Sujit, right? So Suvajit, I'm sorry. So, which is cross examination is when, the defendant's lawyer or the accused lawyer, defendant's lawyer, let's say, cross examines the party who has filed the case. Okay. So let's say the plaintiff has filed certain case. Mukesh Ambani and Anil Ambani example, let's go to that again. In that case, Mukesh Ambani has filed the case against Mr. Anil Ambani. What will happen in cross examination is that Mr. Anil Ambani's lawyer will come and he will cross examine Mr. Mukesh Ambani. He will ask him questions that did the defamation really happen? What did Mr. Anil Ambani really, do that caused you harm? What was the harm that was caused to you? Where is the defamation and everything? Basically, this is done in order to put his case in doubt. Okay. Did you guys follow cross examination? Suvajit, everyone clear? Suvajit, are you there? Did you follow? Everyone else, can I get some responses on the stages of proceedings? If everybody has followed every stage. Yes, guys. Is it necessary to mention about the witnesses in plain? Not necessary, Brahma. You can also later on produce a list of witnesses that you're relying upon. Everybody else clear with the stages? Yes, guys. Okay, amazing. Okay, now let's move on. Okay, and we have a lot of fun topics now coming up after the key stages are done. Okay, now this is where I wanted to discuss a few practical documents. Okay, and what are the terminologies that are used in these documents. Okay, first, as you can see on the screen, is the legal notice. Okay, legal notice is nothing but a document which is sent by the lawyers. Okay, to the other side, okay, to the other party, whoever is against that client. Okay, okay, in Mukesh Ambani and Anil Ambani, of course, Mukesh Ambani's lawyer will first send a legal notice to Anil Ambani saying that how you have committed the act of defamation and everything, right? Now the key terminologies is basically the parties who are there. Now the one who sends the legal notice is the lawyer, correct? So lawyer will naturally write that I am sending this legal notice on behalf of my client, Mr. Mukesh Ambani. Addressee naturally becomes the party to whom the legal notice is addressed. Okay, so very simple. Anil Ambani will become the addressee. Okay, so these are the two important parties who are there in legal notice. Okay, structure is very simple. You, of course, it's on the letterhead of the advocate. There is subject, reference, details of the addressee, introduction as to why I'm sending the legal notice. Then you go to the facts. Then you go as an advocate to the harm that is done to your client, whatever harm may be done. Okay, then you ask for the demand, and then you give a time limit for that demand. Let's say in the builder example, I will send a legal notice. I meaning my advocate will send a legal notice to the builder saying that, see, boss, this is the subject. I am sending you the legal notice because you have come with a JCB to my client's house. The facts are this: you had entered into an agreement, etc., but you are a criminal. Harm done to my client is that he doesn't want to enter into any agreement with a criminal, and he doesn't want his house to be demolished. Demand is that please do not take any action in furtherance to that agreement or contract, and you are requested to comply with this legal notice in writing within 7 days. So this is the kind of legal notice that works. Okay, everybody clear with legal notice? Any doubts on legal notice, guys? Clear? Okay. Plaint, I want to understand from you guys, who will be the parties in a plaint? The way legal notice has client and addressee, who will be the parties in a plaint? Plaintiff, okay, absolutely correct. Who's the second party, guys? Plaintiff and defendant. Okay, amazing. So I'll just note that down. Plaintiff and defendant. Okay, very rightly answered, guys. Thank you so much for that response. Okay, so plaint also has a structure where cause title. Cause title is a litigation term. Let's understand that cause title is basically just covering the details of the court in which the case is filed and the details of the parties. That's all. Okay, we call it cause title. Okay, then in a plaint, what you will do is you will cover the introduction, the facts, the grounds, and then what you are seeking from the court. Okay, this is we are just discussing the brief structure, okay, of these documents. Okay, then you have FIR on the criminal side. Okay, in FIR you have complainant and accused. Guys, make sure you're noting down the parties. I remember when I was in law school, I had a lot of confusion over the different kinds of parties. Why respondent? Why not defendant? And this and that, right? So there is a table right in front of you where you can take down everything. It can for all the law students, it can 100% help in moot courts. Okay, FIR you have complainant and accused. Okay, complainant is the party who files the FIR. Accused is the party against whom the FIR is filed. Structure is that you address it to the police station. You give the reference or the subject. Then, of course, comes the why, the introduction, and then comes the facts and what you want from the police. Of course, in an FIR, first information report, what you want from the police is to register an FIR. Okay. So these are some of the legal documents. Screen is not visible. Guys, is my screen not visible? Just one. Akansha, is my screen visible?
It is perfectly visible. Others, yes, it is visible. It is visible, Shashank.
Okay, okay. Oh, okay. Thank you so much. So these are some of the legal documents. Let's look at some more, okay, which may create a little bit of confusion, but not anymore. Okay, look at this table and let's understand. In an appeal, the party who files the appeal becomes the appellant. The party against whom the appeal is filed becomes the respondent. Okay, so don't get confused between defendant and respondent. Defendant is only and only used in suits and plaints. Okay, respondent is there in appeal, writ petition. Okay, that way. Structure is now in an appeal. What you do is you do not go into the facts in detail. We're just discussing this as a concept, guys. You do not go into the facts in detail. You are filing an appeal, correct? Here you are basically you have a grounds of appeal where you are trying to tell the appellate court, the higher court, as to how the lower court went wrong in its decision. Okay, so that is the focus of appeal that we need to understand. Then you have writ petitions and PILs. PIL is basically public interest litigation. Writ petition is basically a remedy which is available before the high courts and supreme courts. There are five kinds of writs which are there: habeas corpus, mandamus, right? There are these writs. Now, what happens in a writ petition is, let's say that if I feel that my brother has been illegally arrested by the police and they are not leaving him. Now I have to immediately and urgently move the court, right? So I can file a writ petition in the high court and I can say that please allow this writ petition and allow this writ of habeas corpus, and please ask my brother to be produced in the court. So writ petition works differently. They can only be done in the high courts and supreme courts. Okay, they cannot be done in the lower courts. Last part that you see on the table is application. Now, application, the way we discussed in the builder example, interim application. In that, even though I am the plaintiff, I become the applicant in that case, in that interim application. Why? Because I am filing the application, correct? And the builder, naturally, whoever, if he's the defendant, he's the defendant. You can also file applications in appeals and everything. Okay, so that is how these legal documents work. Okay, now you guys tell me if you guys have followed the key terminologies and structure of these uh, legal documents. Yes, guys, clear? Okay, great, great. Okay, so moving on now. Also, let's look at hierarchy of the courts, so that this entire discussion about where to file a case and how to go about it, that becomes very clear. Okay, so what I've done is I've started with the lowest court. Okay, for civil as well as for
Uh,
criminal.
Shank, just 1 second. I'm so sorry to interrupt.
No
Before we
problem.
start the hierarchy of courts,
Yeah, yeah.
I really like to, make sure that everybody is clear until here. So we have a lot of questions. So let's
Okay.
quickly address a few
Yes,
of
yes.
them.
Let's.
Okay. So okay. All right. So Asifa is asking injunction. Okay, again the same injunction under SRA. injunction is temporary or permanent?
Under SRS, specific relief act, you mean?
Yes.
Okay, is permanent or temporary? You have both types. Okay, injunction can be temporary or permanent. You have separate sections which provide for that. A permanent injunction basically will operate throughout. Okay, temporary injunction will operate for a certain period of time. Asif.
Okay, great. So Shashank, remember we discussed about parallel proceedings, so I think people are getting a little confused. So Purva is asking if in a certain case, if there's a civil remedy also, and there's an option to file criminal case also, then in that case, what is the remedy? Like, are we not supposed to go both? And where if there is a criminal element
If
involved?
it yes, if it is allowed by law, please go ahead with parallel proceedings. Okay, I gave an example of consumer and RERA. Right now, consumer and RERA can be initiated simultaneously. These are two very different remedies, and courts have held that you can approach both these courts simultaneously. So what the people do is they approach both these courts simultaneously. Even in the example that the learner just gave, if a criminal and a civil remedy for a particular case is available for both the situations, you can do it. The only point is it has to be allowed under law. That's all. Okay.
Okay, great. About regarding court fees, so Shashank, Somnath is asking where do we find the court fees amount from?
Okay, so see, depending on where you are filing the case, okay, let's say you are filing the case in court in Delhi, you will have to refer to the Delhi Court Fees Act. Okay, over there will be a table given where there will be the valuation of the plaint given, and against that there will be the percentage of court fees that you have to pay. If you are filing the case in Maharashtra in a court in Bombay, Pune, Nagpur, anywhere, then you have to refer to the Maharashtra Court Fees Act or the Bombay Court Fees Act, where again there will be a table given. So it all depends from state to state. All you have to do is just refer to the legislature of that state or the act of that state.
Okay, great. What if somebody is not able to pay the court fees? Satyam is asking. You have to pay the court fees, Satyam.
Yes, you have to pay the court fees. Unfortunately, there's no exemption on that.
All right. In criminal cases, how is the amount of court fees decided?
Okay, so in criminal cases also these court fees act apply, but generally in criminal cases you will never find an ad valorem or a percentage basis. Let me put it in very simple words: a percentage based court fee required to be paid. For example, if I file a suit for 10 lakhs, the court fee act will require me that you pay this much amount of court fee because your value is of 10 lakhs. In a criminal case, there is no per se valuation involved, so there is a nominal court fee that is prescribed by the Court Fee Acts of 250, 300, something like that, depending on state to state.
Okay, great. What is the difference between judgment and decree and preliminary and final decree?
Okay. So judgment is the final order which is given by the court which decides all the issues that we discussed. Okay. And decree is the decree is that part of that judgment which requires execution. So in judgment, the court will decide the rights and liabilities of the party, will decide everything, the entire issue. In the decree part, the court will decide how that judgment will operate, who will do what exactly, how much share is to be transferred to whom.
Okay, great. Some very basic questions. I think I'm really, really happy you guys are asking these questions. These are
Absolutely.
basics, but so important. What is the difference between? Sorry, I'll come to that question. Is the check bounce case a civil case or a criminal case, Shashank?
Criminal case, strictly speaking, because the provisions of CRPC or now the new law apply. But the procedure is summary. But to answer it technically correct, it is a criminal case.
Okay, awesome. What is the difference between summons and notice?
Summons and notice are more or less the same thing. They are two interchangeable terminologies. Some courts use issuance of notice. High courts and Supreme Courts use specifically issuance of notice as the term. The trial courts, district courts, criminal courts use the word summons.
Okay, great. Ratio is asking Shashank, what is the difference between the use of the term plaintiff and defendant and respondent and petitioner?
So see, it's very simple. Let me just share it again. Okay. Plaintiff and defendant is there in a plaint in a suit which is filed in the civil court. There the terminology is plaintiff and defendant. Party who files the case is the plaintiff. Party against whom the case is filed is the defendant. Petitioner and respondent you will find in writ petitions, in public interest litigations specifically, wherever there is a petition. Okay. So that is where petitioner and respondent come. and the nature difference is in the nature of document that is filed.
It's really important. I know I can understand it takes time to understand these terminologies, but once you get used to it, it will be very easy. And now Shashank has made it clear also. Okay. I will be sharing the recording of this session with you guys so you can watch it again and revisit those explanations. Okay. All right. Shashank, what is the difference between, Harshita is asking, what is the difference between a legal notice and plaint?
So legal notice is sent by the advocate. Okay. Tomorrow, if you send me a legal notice, I may choose not to answer. But now, after the legal notice has been sent, now what you do is, because I have not responded, you go and approach the court. You file a case against me in the court. Now I am 100% answerable to the court. So the difference is a lot. Legal notice is sent by the advocate to the party privately. Okay. Here I can choose to reply, choose to defend myself, choose to do whatever I want. But plaint is basically specifically filed in the court of law. Okay, now we are before the court. That is the difference.
Okay, great. Shashank, Anya is asking, is the court fees paid through court tickets?
You can pay through court tickets in case of criminal cases where it's less, but generally if it is exceeding let's say 250, 300 rupees, it's not advisable because it will be cumbersome to fill the entire papers with just court tickets. In that case, now all the states have the option of paying the court fees online, so that option can be availed easily.
Okay, great. Just few more questions, Shashank. Um, a lot of them are asking again, what is the examination in chief? So if you could just explain examination in chief and cross examination one more time for all
Sure,
of
sure,
them.
sure. So now in the example that I took, examination in chief, I'm basically, let's say I'm the lawyer of a client, okay, and this client has filed a case for check bounce, okay. My client's case is that the other side has bounced the check and they were liable to pay some money. Now I file a case in the court, okay, under the Negotiable Instruments Act. I go to the court. Now I have reached the chief examination stage. Now here, instead of earlier what used to happen is I would really ask my client to come and stand in the witness box. I would obviously ask him to do the homework. I would only prepare his questions and answers. I would prepare him beforehand. I would ask him questions that, okay, when did you deposit the check, why do you think he owes money? But these are all prepped answers. I have made him do his homework. So courts realize that this is not required. Instead, this party who has filed the case can instead file another affidavit, examination in chief in writing, where all the details of the complaint, all the details of the case can be included along with the documents that are relied upon. So this becomes an examination in chief, where basically, in very simple words, the party who has filed the case is giving evidence. Okay. Conclusion. Cross examination is the next step. Now I have filed the affidavit, I have filed the case, so I have filed my affidavit saying that these are the documents that I rely upon. Now you come in as the lawyer of the other party against whom the case has been filed, and you question me certain things in the witness box. That where did you get the right to file this case from? When did this transaction happen? Here, what you're trying to do is you are trying to create a doubt in the court's mind about my case. You're trying to tell the court with these questions that this man's case is not correct. This is the interesting part that we've seen in movies, right? The only part of legal dramas that movies cover, or these legal dramas cover, that is a cross examination, right? So this is the part where other side's lawyer asks the party who has filed the case certain questions to create some kind of doubt.
Okay, great, Shashank. One more question from Gopika. Is cross examining a witness compulsory?
Yes, it is compulsory. It's a right that is there. Okay. Of course, you can waive off that right. But remember that cross examination is one of the most crucial defenses or defense opportunities that should not be lost. If you decide not to cross examine a witness, it's an opportunity that your client has lost to present his case.
Okay, I think we'll just take one last question for now. Again, I'll come back to questions. Is there, Ria is asking, is there any time limit to pay court fees?
No, there is no time limit to pay court fees, but all in all, till the time the court fees are not paid, your case will not be filed, and you have to make sure that your case is filed within the limitation period. So remember that this court fees, filing of case, signing of the plaint, everything has to happen within the limitation period. Okay, you cannot say that my client had signed the papers and the plaint, but we paid the court fees late, so that's why there was a delay. So you have to make sure that everything is within limitation, including the signing of the papers, preparing of the draft, paying the court fees, everything.
Awesome, awesome. Thank you so much, Shashank, for patiently addressing all the questions.
Thank
Let's
you.
move ahead.
Okay. Okay, guys, thank you so much for that, for those amazing questions. It really, it matters because then, these are really good questions. Now coming to hierarchy of courts, okay. Now, very simple things, nothing complex. For civil proceedings, the lowest court as per CPC, Civil Procedure Code, is the civil court or the district court. These are given different terminologies in different cities. Some are, in some cities we call them the city civil court, in some cities we call them the district court, in some cities we call them the civil judge junior division, senior division, that way, right? This is the lowest court for institution of civil proceedings. So if your pecuniary jurisdiction is within this court's power, you have to file your civil case over here. For criminal proceedings, remember that you can file your case before the Metropolitan Magistrate Court or the Judicial Magistrate First Class, as they are called. Okay. Now, just remember this one fundamental, that for criminal cases, you can approach the courts directly or you can approach after an FIR. So you can approach the police, and the police can then file a case in the court based on that FIR. Then your case gets converted into then your FIR gets converted into a case. Or you can also directly approach the court, okay, based on a complaint. Again, remember that you have to approach the lowest court possible as per the provisions of law. Okay. In criminal, however, remember that appeals from the lowest court, which is the Metropolitan Court or the Magistrate Court, that appeal lies before the Sessions Court. Okay. That is all about institution of civil cases or criminal cases. Okay. Coming at the next appellate stage, which is very interesting, again, high court. Okay. Every state has a high court. Okay. They have benches and everything. Now, high court is basically, the court for hearing appeals from the decisions of civil courts and the criminal courts. Okay. That is the basic understanding that we need to have today. It is also the court for institution of certain civil proceedings. Like I said, in the first 5-10 minutes, I had given an example of where the pecuniary limit of the suit exceeds, say, 20 crores, 30 crores, then you need to directly approach the high court. You cannot approach the lowest court. They are also called the writ courts. You can file your public interest litigations and everything over there. They are having the power to issue probate and all of that. So that's all about high court. Lastly, we come to Supreme Court. Very interesting subject, right? Appellate side, original side is nothing complex. Appellate side is basically the power to hear appeals. Original side is when directly the Supreme Court is approached instead of challenging some decision of any court. Okay, so there are two ways you can approach the Supreme Court. Just remember this. One is original side. Let's say you want to file a public interest litigation or a writ petition, you can directly approach the Supreme Court without approaching any lower court. Okay, of course, if it pertains to your state, then it is advisable to approach that high court first. Appellate side, appellate word means appeal. Okay, let's say the High Court of Bombay has passed a decision against your client. You have a chance to appeal to the Supreme Court by filing a special leave petition. So these are the only two ways in which you can approach the Supreme Court. Did you guys follow the hierarchy of courts till here? Yes. Okay. Just to briefly cover, apart from this, there are few special courts and tribunals. For consumer disputes, you have Consumer Forum. For real estate disputes, you have RERA tribunals. For company law and IBC, insolvency matters, you have National Company Law Tribunals. Cooperative society matters, you have registrar. Labor disputes, you have labor courts. Debt recovery matters, you have debt recovery tribunals, DRT. Tax matters, tax tribunals and commissions. So the reason why I'm covering this is that always be aware that if your client's dispute is falling into a specific forum, make sure that you are approaching that special or specific forum. Okay, everybody clear? Yes, guys. Okay, now court craft, something again very interesting that I wanted to just cover. Okay, terminologies for addressing judges and counsels is the first block that you see. This is something very interesting. Okay, so in India we use the terminology for addressing judges is your lordship, okay, or my lords, or your honor. Okay, the reason is that there is that kind of respect that is required to be given to the judges. It is not specifically personally to the judges, it is the respect to that forum, that court. Okay, that is in that power. Okay, for opposing lawyers or for the opposite side's lawyer, you generally use my learned friend. Okay, and again, the reason I'm explaining is that once you visit the courts for actual hearings, you will 110% see these terms being thrown around by lawyers. Okay, dress code is the second fundamental. Guys, remember, it has to be as per Advocates Act. I will not go into depth of that. It has to be formal. In high courts and Supreme Courts, you have to wear a gown also. Okay, all those things are very clear. Code, decorum, and body language. Okay, now this is something very important. It's important to have a pleasing body language specifically towards the court. Okay, a smiling face would help. It's important to not get aggressive, not shout at the court, not shout at the other side's lawyer. Okay, you can of course raise your voice in certain situations if required, but never at the court. So there is a decorum to be maintained. You have to go down to the judge every time the judge sits, stands, or enters the courtroom, exits the courtroom. When you are entering the courtroom, these are basic mannerisms which definitely go a long way. Preparedness is again needless to say. Always go prepared with your case. Never assume that a certain part of the case will not be asked or touched upon by the court or the opposite side lawyers. It can happen that the court may ask something out of the blue, and it will not be a very good face to show if you do not know the facts properly or know your grounds properly, do not have certain judgments or something. So preparedness is something, just being absolutely 200% well prepared about your case. What to say and what not to say is very interesting. If I may just go back to the builder example, uh, the builder example was that the builder is trying to demolish my house. In that story, let's also put one more fact. Let's also assume that this builder is trying to put some kind of defamation article against me in the newspapers. He's trying to defame me in the newspapers. Now, guys, when I go and approach the court for an interim application saying that, why? Because he's trying to break my house, it is very important that in the first instance, I tell the court that he's trying to break my house, not that he's trying to defame me, because it is an interim application. So, what to say and what not to say is very important. If I go to the court in an interim application and say that, he's trying to defame me, the other side's lawyer also will be very happy. The court also will be very happy deciding that first, and the builder will go and demolish my house. So, it's very important to pick and choose what to speak and what not to speak. Okay, that's just, I thought it's an example that I could use. Okay, so this is all about code craft. Okay, did you guys follow this? Any any uh, any issue on this, any doubt on this, anything that you guys did not follow on the code craft? Clear, everybody? Okay, coming to a few do's and don'ts. Okay, I thought it's important that I cover these, and these are mistakes that a lot of us do. Even not that I am not done, everybody commits mistakes. So do's, let's start with the do's. Start arguments with addressing the court first. Okay, it's important that you go to the court with, of course, a pleasing body language and tell the court, please your lordship, or please my lords, whatever may be the your situation, but please first inform the court that you're there. Okay, first say this. Second do is, first start with informing the court about what party you represent. This is something very crucial. I've seen cases where lawyers just start arguing, and after 15 minutes of arguing, the court ends up asking, whom do you represent, boss? Whom are you here for? So it's very important that you say that I am for the defendant, I am for the plaintiff, I am for the respondent, I am for the petitioner. Okay, keep the court informed. Third is, always better to inform the court about the present state of proceedings. Okay, instead of going on arguing about the entire case, first tell the court that today this case is listed for deciding the injunction. Inform the court this. Otherwise, in thousands of cases that are listed per day, court will not be able to keep a track. And lastly, remember that your first duty is towards assisting the court. You are an officer of the court first, and then your client's advocate. The reason I mentioned this is that there will be times when a client may suggest misleading the court or not disclosing the entire facts. But remember that if asked upon, remember that your first duty is towards assisting the court. So you must first disclose and inform the court everything when asked. Okay. Don'ts are, avoid interrupting the opposing counsel, needless to say, unless necessary. Okay. Avoid interrupting the judge. I would say this is not only avoid, just don't interrupt the judge ever, especially during dictation of order. Do not hesitate to apologize. This is something that I'm sure all the litigators will agree. Uh, I have also apologized 1,000 times. Every day I go to court, I end up apologizing at least 10 times, because you don't want to catch the judge on a bad temperament. Do not make any submissions without the client's instructions. Again, very crucial. If your client has said that they are not willing to settle the dispute, please do not make a submission that you are willing to settle the dispute. Your client will come and may file a case, bar, he may file a case against you with the bar council, or he may just in general inform the court that, this was not the instruction that we had given. So make sure that you have complete instructions before making any submission. So this was all on court craft. Did you guys follow? Everyone clear? Any doubts so far? Okay, okay, great. Akansha, do we have time? I'll carry on with the next slide.
Yes, maybe we can take questions after you are done with the PPT.
Okay, next part is something that I wanted to, show you guys, on my screen. E-courts is basically the website which is used practically for, majorly for tracking your cases, as an advocate for tracking your cases in all the district courts all over the country. Second is cause list. Cause list means the list which is published by every court. Okay, let's say I have my case listed before the Bombay City Civil Court tomorrow. So what the City Civil Court will do tonight, they will publish a cause list in which they will give a list of the matters, list of the cases which are listed the next day along with their serial number. So my case may be at serial number 50. That means it will be called out after the first 49 cases are called out. So this is a cause list. Okay, every court has its cause list published every day or weekly. Also, Supreme Court, High Court, all the courts in the country. And past orders is basically all the previous orders that have been passed in, my case. Okay, so this is all about e-courts. If I can just share the screen, I'll just share the e-courts website. So this is how the e-court websites looks like, guys. Is everybody able to see my screen and the e-court website that I'm navigating right now? Everyone? Okay. In this, you can also look at the status and cause list of the Supreme Court, High Court. Okay. I use it for district courts because High Courts already have their own website. So over here, how you can do is you have the options of tracking the case status by case number, case type, FIR, case code, whatever. Court orders also you can, track and download, and you can also download the cause list for your cases that are listed the next day or something. Okay, this is a very simple and very user friendly website, that the government has established. It's very helpful. Having said that, that's all about e-codes. Anyone, any doubts on the functioning of e-codes or navigating through e-codes or anything? Perfect. Okay, okay, awesome, guys, awesome. So I'm glad. Okay, now we've reached the one of the most favorite slides today. Okay, that is the career as independent litigator. Now, this is something that I specifically wanted to cover because, I've also started my litigation practice, and I faced some hardships. Okay, had there been a webinar like this in my school days, trust me, I would have also benefited a lot. So the three things that really helped me being, a first generation lawyer is, one is litigation internships. Okay. Now, when I say litigation internships, I of course don't mean to say that, don't do corporate internships. In fact, do both. Okay. And get a clear idea of what you want to do. Once you are 100% sure that you want to do litigation, make sure that you are doing more internships in litigation. Okay. In litigation internships, you will get to learn a lot about drafting. Make sure that you observe court proceedings. That's the second point. As a law student, as a learner, you will have a lot of time. Okay, I'm not saying that, don't do other activities, but whenever you get the time during internships or otherwise, you can just go and sit in the courtroom and observe court proceedings. Even today, if my matter is listed before the high court, trust me, the only most amount of learning that I have done about arguments is by looking at other seniors and other people, argue their case, and it's extremely helpful. Okay, more than anything else, just observing court proceedings, how lawyers find smart ways to navigate, to overcome their problems, overcome their struggles. It's very interesting, and it's like it's you'll enjoy it thoroughly. And third is learning and understanding drafting. This again, I wish I would have done more in my law school days, because it's a 5 year or a 3 year course. You have time to learn and understand different drafts. There's a lot of courses, there's a lot of material available free of cost online. So there is no end to that. There are a lot of books available, lots of resources and material available, but make sure that you read these drafts, try and create imaginary scenarios, and practice drafting as much as possible.